Hello, everyone, and welcome to America, Some Assembly Required. Anna hasn't joined us yet, but today is Tuesday, July the 1st, 2025, and we're going to start talking about and looking at the Constitution for the United States. So until Anna joins us, we'll be looking at that Constitution. So I'm going to put that up on the screen. And I also wanted to let you know that if you scroll up in the comments section, I put a link to the document that we're going to be talking about today so that you can download your own copy and have that for your assembly. So make sure that you're scrolling up and taking a look and grabbing that link and putting that link in your browser, and you can download a copy of that of the Constitution for the United States. So I'm going to take and put that up here on the screen. And hopefully I can find it in my messy screen. It doesn't seem to want to share that. So let me go back here. And we'll get it picked up here. You may wish to do that as a PDF. So get it in that form and get it up. So I hope your Tuesday is going well. We're hopefully it's not raining or storming where you are. Now we're going to get that up here for you. There it is. Okay. So as we begin to talk about our International Business Assembly, we need to know exactly what our parameters are, because our International Business Assembly has to hold ourselves to this contract. This is what anybody that comes to work for our assemblies, this is how they need to be treated, and this is the business that we need to keep our eye on. And then as it progresses and we talk about the constitutions of the United States of America, then we'll know exactly where our borders and our lines are and what we can affect and what we can't affect. And for the most part, the voice of the people is the most important part. And the voice of the people is going to guide and direct our subcontractors in the United States of America to our wishes and our desires for our states. So as we go through this, it's important for us to understand exactly what we've delegated and what we haven't delegated, what remains with the people. So as you can see, this is established this Constitution for the United States of America. So Section 1 says all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. So there's the establishment of our two houses, our two branches of that operate our governments. And then Section 2 says the House of Representatives shall be composed of members chosen every second year by the people. See the capital P in people? That means it's citizens who vote on those House of Representatives of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. So no person shall be a representative who shall not have attained the age of 25 years and been 7 years a citizen of the United States. So we have to remember that in this time period, that many of the people who were here maybe had not been here 7 years. There was still a great deal of immigration going on, and constant flow in and out of our states. And so they had to put that qualification in to make sure that they weren't just necessarily getting British Tories in or foreign agents into the government, and make sure that they were well settled here in our states. Who shall not, when elected, be an inhabitant of that state in which he shall be chosen. So age of 25 years, has been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant of the state in which he shall be chosen. So he's no longer claiming his state national and his only allegiance to our states at that point. So it's real important that we understand that is what was required of our representatives when they came into our first Continental Congress. So in our Confederation of States. So representatives and direct taxes shall be apportioned among the several states, which may be included within this union. So at the time, taxes, they determined what was going to take to operate the federal government, lowercase federal government, and then they would spread those taxes out among the states to pay. So if it took $1 million and there were 13 states, they divided that 13 ways. As it grew, it became less and less and less, so that, or it became more. In our case, we've seen it become much more in our lifetimes, to where they've grown that without really regard to how they're going to actually collect that within the states. So taxes apportioned among the several states, which may be included within this union, according to the respective numbers, which shall be determined by adding the whole number of free persons, including those bound to service for a term of years, meaning indentured servitude, because there were a lot of people who accepted indentured servitude in order to pay their way here to the New World, to the Americas, and including those bound to a service for a term of years, including Indians not taxed, meaning that the indigenous people of North America were not taxed, and then 3/5 of all other persons. So the elephant in the room here is the fact that in that time period, we know slavery was very prolific. They bought slaves over from Africa, from Ireland, from various parts of the world, and they worked the plantations and some of the large farms and things that were established at that time. Now, notice that says 3/5 of all other persons. Now, what that didn't actually apply to each individual man or woman. It's been a big misnomer, and was a huge misnomer, especially spun during the Civil War. What they would do is take the whole population of a plantation, of the people who were there as slaves, and they would only count the whole population and give a 3/5 number. It wasn't 3/5 of a man, as it's been reported or spun in the politics. It was 3/5 of the entire population of of the plantation. And that was because the southern plantations were starting to grow, and as they continued to acquire more land and more plantations sprung up, the populations of those plantations could easily overwhelm the city and the smaller states, such as Rhode Island and Delaware, in terms of delegate votes. And so this was their compromise to be able to kind of hold representation into their for their senates and their House of Representatives. Okay, so then this was modified by the 14th Amendment that did away with that particular qualifications, because they were also doing away with slavery and the plantations themselves in many ways, in the way they operated. And they now had the ability to, basically free their populations where they had to be paid. However, many of them were paid by their room and their board, and that was all they got. It was enough, and they would take that for their room and their board. So there was a lot of different things that went on in that time period. The actual enumeration shall be made within 3 years after the first meeting of Congress of the United States, and within every subsequent term of 10 years. Now, this is where our census was established, is right here, within every subsequent term of 10 years. So that's why there's a census conducted in the states every 10 years to determine representation into our Congress, in such a manner that they shall by law direct. The number of representatives shall not exceed 1 for every 30,000, but each state shall have at least 1 representative, and until such enumerations shall be made, the state of New Hampshire shall be entitled to choose 3, Massachusetts 8, Rhode Island and Providence plantations 1, Connecticut 5, New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Virginia 10, and North Carolina 5, South Carolina 5. So you can see how they were trying to control some of the density of the populations they had by the number of representatives that they had in each of those areas. When vacancies happen in the representation from any state, the executive authority thereof shall issue writs of election to fill such vacancies. So at that time, the executive authority in a state was meant to be the governor of the state. And we would hope that eventually that would have changed, however it didn't, to be a choice by the representatives who were electors from the various counties and things on your state. So the House of Representatives shall choose their speaker and other officers, and shall have the sole power of impeachment. So there is where the power of impeachment comes into discussion within our first Constitution. Okay. So Section 3, the Senate of the United States shall become composed of 2 senators from each state, chosen by the legislature thereof. And of course, it was modified in the 17th Amendment, for 6 years, and each senator shall have 1 vote. Now, the hope was that they were carrying the wills and the wishes of their state citizens with the senators. Okay. They immediately after they shall be assembled in consequence of the first election, they shall be divided as equally as may be into 3 classes. The seats of senators of the first class shall be vacated at the expiration of the second year. Of the second class, the expiration of the fourth year, and of the third class at the expiration of the sixth year, so that 1/3 may be chosen every second year. And if vacancies happen by resignation or otherwise during the recess of the legislature of any state, the executive thereof may make a temporary appointment until the next meeting of the legislature, which shall then fill such vacancies. This was done to start the continuity of our government, so that was never a fully new class coming in and trying to run what they envisioned would be a vast government. And so they staggered the expirations to begin with in the first few years in their first election, so that every 2 years, so 2 years and at 4 years and at 6 years, there were a change of representatives. So it kind of started the churning and the ability for them to keep the continuity of government, but also be able to have those elections come into place that would continue that and perpetuate that on into many years. So no person shall be a senator who has not attained the age of 30 years and been 9 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state for which he shall be chosen. So his allegiance comes to the Congress, not to the state on which he was originally an inhabitant of. The Vice President of the United States shall be President of the Senate. That's still true today, but shall have no vote unless they be equally divided. So his vote is reserved as the tiebreaker vote. Okay. So the Senate shall choose their officers and also a president pro tempore in the absence of the vice president, or when he shall exercise the office of President of the United States. So if the vice president gets moved up to the office of President of the United States, then they have to choose a new president pro tempore to have and preside over the Senate. Senate shall have sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. All right, so some people have the religious objection to oath, and many prefer to have their positions affirmed within theirs. Within our assemblies, we affirm our positions. We do not have an oath to any particular body politic in that way. We affirm ourselves to our people. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without a concurrence of 2/3 of the members present. Judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law. So impeachment is really, it is not necessarily makes it a criminal act. It's more of a reprimand in many ways. In our original Constitution for our Confederation, 1787, however, it was a little more serious than it is in the current Constitution, where impeachment could be removal, but many times it is just more or less a serious reprimand within the Congress or the Senate. Really depends on what crime or what evidence that they had to the whole thing. We've been exposed to only a few in our lifetime impeachments. And, for example, Bill Clinton was impeached. He continued to be president. We saw where, President Trump was impeached twice, and continued to be president, essentially. So they're very serious reprimands, but they're not necessarily, unless they involve a great deal of criminality, where they can be actually removed and then indicted and then go to trial and judgment. They have to be out of office for that, and you're going to see that in later areas of this Constitution. Section 4, the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislatures thereof. But the Congress may at any time, by law, make or alter such regulations. By law, which means it has to be written into the congressional record, except to the places of choosing senators. The Congress shall assemble at least once every year, and such meeting shall be on the first Monday of December, modified by the 20th Amendment, unless they shall by law appoint a different day. Each house shall be the judge of the elections. Section 5. Each house shall be the judge of the elections, returns, and qualifications of its own members, and a majority of each shall constitute a quorum to do business. But a smaller number may adjourn from day to day and may be authorized to compel the attendance of absent members in such manner and such at penalties as each house may provide. So they can make rules to force members to be there. They can actually send out law enforcement, U.S. Marshals, and have to compel certain people to show up to vote, to attend, and be present for the meetings. They need to do a whole lot more of that, in my opinion. So, Section 6. Senators and representatives shall receive compensation for their services to be ascertained by law and paid out of the Treasury of the United States. They shall, in all cases, except treason, felony, and breach of the peace, be privileged from arrest during their attendance at the session of their respective houses. I'm going to stop there for a second because that's real important and germane to some of the news that is going on right now. They've arrested some of the representatives for creating, basically, and breaching the peace with their appearances at ICE facilities and certain areas that they've been in where they've tried it and brought a crowd with them, or a mob with them in certain areas. And you're going to see that become even more prevalent. And they do have the ability to prosecute them, even though they're in office, for that, because the Constitution specifically prohibits that for members of the legislative bodies. And in going to and returning from the same, and for any speech or debate in either house, they shall not be questioned in any other place. So no senator or representative shall, during the time for which he was elected, be appointed to any civil office. So he can't dual time. He can't be on both sides of the fence. He can't serve two masters. Under the authority of the United States, which shall have been created, or the emoluments whereof shall have been increased during such time. And no person holding any office under the United States shall be a member of either house during his continuance in office. So this is where we cannot hold two masters. And so, this clearly sets up the idea that we have to, when we step up for office, that particular office, whether that's a civil office or whether that is within our Confederation offices, our assembly offices, or, when we get to a Continental Congress, within those offices, that we will be able to serve in two capacities at any one time, one capacity at a time. So Section 7, all bills for raising revenue shall originate in the House of Representatives, but the Senate may propose or concur with amendments as on other bills. Every bill, and remember, when they make a bill, someone has to pay for it, right? That's where the name comes from. So when they're raising bills, they're basically taking from our credit to raise revenue enough to service something. And hopefully that revenue produces a neutral base. But we haven't seen that in many, many, many years. And just a particular commentary on current events, the big, beautiful bill that was just passed is going to cost Americans $5 trillion over the next 3.5 years. As they put it in one of the commentaries that I saw from one of the congressmen, is that there will be enough funds to make it through the Trump administration without having to vote any additional funds. So every bill which shall have passed the House of Representatives and the Senate shall, before it becomes law, be presented to the President of the United States. If he approve, he shall sign it. If not, he shall return it, with his objections to that house in which it shall have originated, who shall enter the objections at large on their journal and proceed to reconsider it. So if you are paying attention to some of the prior sessions, when we talked about committees and things that committees were going to propose and vote on and pass along to our General Assembly, this is the same thing where the General Assembly, we don't have a president to veto it, but the General Assembly can return that to the committee with their objections, and the committee can continue to work on it, right? So that's kind of a small tie back into our assemblies. So who shall enter the objections at large in their journal and proceed to consider it. After such reconsideration, 2/3 of that house shall agree to pass the bill. Now, we don't require 2/3 in our assemblies because we have direct vote. So every member's vote counts. So it's not a necessary, we're a simple majority in our form of government, in our Republican form of government. So 2/3 of the House shall agree to pass the bill. It shall be sent together with the objections to the other House, by which it shall likewise be considered. And if approved by 2/3 of that House, it shall become law. But in such case, the votes of both houses shall be determined by yeas and nays, and the names of the persons voting for and against the bill shall be entered on the journal of each house respectively. If any bill shall not be returned by the president within 10 days, Sunday it was accepted, after it shall have been presented to him, the same shall be law in like manner as if he had signed it, unless the Congress, by their adjournment, prevent its return, in which case it shall not be law. So again, this is where we're coming from our assemblies, and remember, they're coming out of our assembly model. If it's returned back to the committee that it was initiated in, and the committee says, we're not going to accept any objections and they're not going to vote on it, it can die in committee. And, our ideas is to try to work to overcome objections, to look at it critically, debate it, research maybe some more, and then try to get to a compromise, to a win-win with our things, especially when we know that it's going to be something that's really good in the development of our assemblies. So, some people have said, well, but I get voted down. Well, then we have to know why you're getting voted down. We have to know why the vote is not desirable. Is there research? Is there facts? What is it? And what can we do to kind of work within that framework to get our issues and our basically our wishes as people stated, our processes and our procedures adopted within our assemblies. So every order, resolution, or vote to which the occurrence of the Senate and House of Representatives may be necessary, except on a question of adjournment, shall be presented to the President of the United States, and before the same shall take effect, shall be approved by him, or being disapproved by him, shall be repassed by 2/3 of the Senate and House of Representatives, according to the rules and limitations prescribed in the case of a bill. So they call that override, right? Where they override a president's veto. Okay. Section 8. The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and the general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States. So they weren't allowed to say, for example, well, South Carolina, you have to pay more. You've got 2 more ports than anybody, and you're going to have to pay more of this bill because you have the revenue coming in or the revenue going out to pay more of the tax. No, it was exactly a portion to each state, and each state then had to, at that time, be able to take care of the debts of the federal government. That no longer happens today, I can tell you. And so it is unfortunate that we weren't a little more exact in our language with this, but the idea was that those taxes and duties and imposts and excises, which essentially tariffs are part of those excises and imposts, then those would take and negate the debt, and so it would zero out the debt itself. It's part of what you see happening today. So Section 8, the Congress shall have the power to lay and collect duties, imposts, imports and excise shall be uniform throughout the United States. So to borrow money on the credit of the United States. Well, I always ask, what is the full faith and credit of the United States? Well, what they meant was you and I. Our life works. That's who we are expected, and that's what we are expected to do in terms of the production and the ability to export and import and consume in many ways. It was never meant to be a full consumer base. We were meant to be manufacturers and exporters as well. To regulate commerce with foreign nations and among the several states and with the Indian tribes. So they wanted to be able to do that trade, but they also wanted to make sure that it was reciprocal between those different nations and states, because we have to remember that every state at that point had an excise tax that coming into their state with goods from outside got charged a tax. If it was made in the state, it didn't get taxed. And so it was to really encourage that cross commerce between the states in an even and fair manner, but at the same time to other nations, which we were still importing a lot of woolen goods and produce and those types of things from over in Europe. And then also to encourage within the Indian tribes, which still at that time regarded certain areas as their Indian nations. So, and to be able to work within the Indian tribes as well. So to establish a uniform rule of naturalization, this is where they came up with the Naturalization Act of 1779, which is not exactly the same thing that we've signed, but in essence it is. That's what's allowed us to come back to the land, declare ourselves as Americans, because that is the act, the Naturalization Act of 1779, that allowed them to do the sorting between those who wanted to remain and call themselves Americans and those that wanted to remain loyal to their foreign crown, whether that was England or Spain or France or Holland or wherever. Okay, so that was important, that eventually they would put that rule in 12 years later. Remember, this is 1787. They had to work on that immigration law, and among the several states and with the Indian tribes. And uniform laws on the subject of bankruptcies throughout the United States. So at the time, bankruptcy was a real black mark, because there was none of this, in a way, forced bankruptcy or fraudulent bankruptcy at the time. Yes, there were some, but not in the widespread application of what bankruptcies are today. And so, and bankruptcy was really a social mark upon a man when he went bankrupt. His family could be sent, could lose everything and be just on the streets to beg. So to coin money, regulate the value thereof and of foreign coin, and fix the standard weights and measures. So originally, to coin money, that the colonies did not each of them produce their own type of money. And before the Revolutionary War, the colonies had what they called colonial dollars, and they were paper that were traded based on, but they were all different, and they would value them different between states. So you can imagine someplace like Massachusetts or New York would value theirs higher, and any goods and services that would flow would be inequitable between the states. And so this was going to normalize what coin was going to be able to be used, or what form was going to be able to be used across all of the colonies. And so at the time, the Spanish dollar was the most well-recognized measure at 471.25 grains of pure silver. Of course, pure silver, if you carry it around long enough, no longer weighs 471.25 per ounce, because it's soft and it rubs off. And so they also had a rule of being able to mix it with certain more durable metals, nickel being one of them, and copper. And that way it would produce a durable coin that could be used in the trade of within the money, and the equal value across the assemblies, across the states. And so what they did is they fixed that amount. And then they had the ability to say, well, the Spanish dollar was equal or it was slightly less. And so this is where monetary exchange comes into the concept of our colonies, in terms of the United States holding their monetary exchange. The British pound was always slightly higher. We all know why. The Spanish dollar tended to be of equal value in that time. And the various other types of currencies were weighed against that. And so, again, they would take and fix those standard weights. So this is where our ounce and our pound, not metrics, came into the use of weighing things, scaling things, all of those types of measuring things out, metering, to provide for the punishment and counterfeiting of securities and the current coin of the United States. So they already knew that the British had tried to tank them, basically, by counterfeiting the colonial dollars that were available earlier. And so this is why they went ahead and put that clause in, was to discourage Britain from, or any other foreign country, from getting a hold and counterfeiting our money and flooding our monetary supply, and then being able to inflate because of the amount of money in circulation, or devalue based on a lack of money that way. So there's a rule called Gresham's Law that talks about the addition of those kinds of influences, overprinting of money or underprinting of money. The deflation could be worse than the inflation. So this is where they outlawed basically the counterfeiting of securities, and kind of put the British on notice that they would not put up with that. To establish post offices and post roads. So post roads being the roads connecting the post offices so that they could go ahead and institute the mail service. Now, Benjamin Franklin was our first postmaster. He actually held the contract from Britain for post services, for the mail. And his mail service was called the United States. That was established in 1775, prior to the Revolutionary War. And so Benjamin Franklin wrote this in to make sure that, in a way, it's sort of a gravy train item for him, but that post offices could be established outside of the very concentrated populations of New England, and to develop post roads as the country continued to expand itself into other territories and farther into what they perceived the rest of the territories actually were. To promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Now, that's been kind of hijacked in our current capital F federal government, to where they were funding sciences and arts. That's not what the founding fathers meant here. What they meant was to be able to give them the ability to register their works, so that their works couldn't be counterfeited or stolen out from underneath them, as they began certain inventions. It's today, that's been very bastardized in terms of the usefulness of copyrights and patent laws. because they only need to, at this point, change a small part of it, and it can change someone's or attach to someone's patent, and their patent basically stolen out from underneath them. And that's something that Anna has talked about many times, about getting that corrected. So this is where they establish sort of a protection for artists and sciences, including copyright for writings, music, art, and then also anything in the development of science, scientific development, and manufacturing. To constitute tribunals inferior to the Supreme Court. So they always meant for the courts to be answerable to the Supreme Court. Most of the time, our courts now go, that doesn't matter to me. The Supreme Court says this. We don't care. We say that. Take us to the Supreme Court is sort of their answer. In our original Constitution, though, it says that they are inferior, subordinate to the Supreme Court. To define and punish piracies and felonies committed on the high seas and offenses against the law of nations. So even when our ships, our trading ships, our passenger ships, those things were out on the high seas, they had to write that into the constitutions to make sure that we had the ability that if we were being, our flagged vessels were being attacked in any way, that we had recourse under our Constitution to be able to try their crimes at that time. And so, we never dreamed that piracy would continue on inland, but it has, and it's something that our assemblies will have to deal with on our states. To declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water. So this really, to declare war, only the Congress, the true Congress, can actually declare war, which is why most of the events after the War of 1812 and after 1865 were all mercenary conflicts, because there wasn't a lawful Congress in place, the People's Congress in place, to be able to declare war. Grant letters of marque and reprisal. That's basically the ability to go out and go after a ship or a vessel, and commandeer their ship for the ability for their crime, and make rules concerning captures on land and water. And so during war, they would have to have a way to lawfully capture an enemy combatant. So if you go back and read a little bit in the War of 1812, they had, for example, here on Ohio, we had Johnson Island, which was a very infamous prison during the War of 1812. And that was capturing both Indian and Canadian and English soldiers or naval men on the high seas. So those that weren't killed in battle were then taken and captured and brought in onto land and held in capture. So to raise and support armies, but no appropriation of money to that use shall be for longer term than 2 years. So our armies are not supposed to be funded more than 2 years. What does Anna always say? They're always declaring war every 2 years. Why? Well, because the appropriation of money has to be there every 2 years as well. And that's what feeds the industrial military complex. can see how all this is starting to fit in here and make sense. So to provide and maintain a Navy. This was one of the main reasons that the capital F federal Constitution was given away, is because we didn't have really the ability, nor the money, nor the manpower to create a Navy that would compete with the British Navy or the French Navy or the Spanish Navy. And we also have to remember that at this time was beginning the war between France and England. And so we needed a Navy. We had a small ragtag Navy. And that's what necessitated in many ways the Constitution of 1789, was that need for a Navy to protect our waters, our borders. So to make rules for the government and regulation of the land and naval forces, that's understandable. To provide for calling forth the militia to execute the laws of the Union. That's why it's important for each of our states to have their militia. But there is a caveat to that, and you're going to hear it in the next few paragraphs. So the militia was there to execute the laws of the Union. What union are they talking about? Well, they're talking about our states. Suppress insurrections and repel invasions. To provide for organizing, arming, and disciplining the military, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of officers, the authority of training the militia according to the discipline prescribed by Congress. So the states have the ability then to put their officers or appoint their officers, and the militias can be employed in the service of the United States, but that was more or less for homeland defense, mostly on your state to defend your state borders at that time. If they needed to get a militia from another state to come in to assist a state, then they would do that as well. So it's not the same. It's not like the federalization of our National Guard that has happened where they've been sent overseas. So that's not what this meant at all. Our National Guard, which is basically our militias on our states, those were always meant to be on our states themselves and controlled by our states, not by a military in that way. So notice they established a naval force. Our land forces were always supposed to be militia. To exercise exclusive legislation in all cases whatsoever over such district, not exceeding 10 square miles, as may, by cession of particular states and the acceptance of Congress, become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state, in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. So where is a federal zone considered? Well, they're telling you right here, 10 square miles, that's all that was allowed. And then the establishment of the forts and any magazines, meaning bases, arsenals, the dockyards, so any ports, so ports, and they've expanded that to ports of entry as well. So airports, seaports, and in many towns, many areas, even though their waters are not navigable, they now have port authorities surrounding. And it doesn't necessarily have to be much of a body of water. It could be a pond, and they can set up a port authority, which gives them a federal zone. And whenever we're on federal zones, we have to respect those federal rules. So this was also something that our forefathers didn't necessarily see the usurpation of within the Constitution. Okay, so, and to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. So the migration and importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by Congress prior to the year 1808, but a tax or duty may be imposed on such importation not exceeding $10 for each person. So any migrant or any slave that was brought into the United States they would have to either come up with their $10 immigration or migration fee, or they would have the slave owners would have paid a $10 importation fee for importing people. Okay. The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. Well, if you haven't looked into your state's habeas corpus rules, writs of habeas corpus, most states do not have writs of habeas corpus. And that was pretty much suspended after the Civil War, where the states, and surprise, right, that they would suspend that writ of habeas corpus. No bill of attainder or ex post facto law shall be passed. What is a bill of attainder? Well, a bill of attainder is a debt note. We have lots of them, don't we? And so this is a direct violation of our original Constitution regarding those things that everybody thinks is a US dollar. It's actually a debt note, and it's specifically prohibited in our constitutions. And no law can be passed retroactively. That's what ex post facto means. So it can't go back and punish someone for something that wasn't law at the time. So no capitation or other direct tax shall be laid unless in proportion to the census or enumeration wherein before directed to be taken. That's always been the question about taxes, especially what they considered income taxes at the time. And there have been many challenges to it. There have been some very bad interpretations of the Congress. And there's been a lot of looking the other way on this particular clause in general. No preference shall be given any regulation of commerce or revenue to the ports of one state over those of another, nor shall vessels bound to or from one state be obliged to enter, clear, or pay duties in another. So none of this cross state in the ports. The ports are federal, basically, at this time now, and they're not going to be able to collect duties. The only duties that are taken are basically the tariffs that are coming in from foreign outside of the states into the ports. and that this keeps the ports from playing games and one state having more revenue or more activity in a port than another. So all the ports are equal at this point then. Okay. So you can see the business models that they are laying out in the Constitution here as we go through. So no money shall be drawn from the treasury, but in consequence of appropriations made by law. So they can't, and they just caught a bunch, and I'm sure we're going to see some of that justice coming, hopefully, where they kind of skirted around some of that, put it in certain bills, funneled it through certain agencies. And so this particular clause that's here says that there has to be a law, has to be in the congressional record for that money to be spent. So, so the recoupment of some of those funds is going to be tough, but they've sort of shut off that flow of money out and some of those fraudulent things. Is there still fraud? You betcha. And a regular statement and account of the receipts and expenditures of all public money. So this is something we as assemblies have to be very aware of, and we have to develop our fiduciary policy or processes within our states. If you're putting money out, you have to receive a receipt in. There isn't, well, I think I spent, so you just need to pay me. No, that's not true. We have to have, it is constitutionally correct for us to have a receipt, and any expenditures of public money shall be published from time to time. So your treasury should be publishing monthly their ins and their outs. Simple carriage accounting. What did you spend? What did you take in? What did you spend? What did you take in? And that goes right down to even the local levels within this Constitution thought, is that even our local levels, if you receive at the county level donations in, and your county, whoever in that county spends it, they should be able to show a ledger for that with a receipt attached to it. And this is where it comes from. Okay. No title of nobility shall be granted by the United States, and no person holding any office or profit or trust under them shall, without the consent of Congress, accept any present, emolument, office, or title of any kind whatever from any king, prince, or foreign state. So we just had a big uproar in Congress where the media was dragging this all over about the acceptance of a 747 from the king of Saudi Arabia. And eventually it went through Congress. And Congress accepted that aircraft for the use of the United States. And this clause is one of the reasons why it had to go in that direction. Okay. All right. Section 10. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, pass any bill of attainder, no debts for the states, ex post facto law, or law impairing the obligations of contracts, or any grant and any title of nobility. This is what affects our international business assemblies right here. So we have to be very careful that we, at our level, do not take and violate within our International Business Assembly anything in this section, Section 10. No state, without the consent of Congress, lay any imposts or duties on imports, exports, except what may be absolutely necessary. Absolutely necessary. I'll read that again. Absolutely necessary, right? For executing its inspection laws and the net produce of all duties and imposts laid by any state on imports and exports shall be the use of the Treasury of the United States, and all such laws shall be subject to the revision and control of the Congress. All right. So absolutely necessary. It's not supposed to line anybody's pockets. It's not supposed to create slush funds. We're supposed to be a zero-in kind of entry, a balanced entry. And if we do collect it, it really says right here that it belongs to the federal government. No state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in time of peace, enter into any agreement or compact with another state or with a foreign power, or engage in war unless actually invaded or in such imminent danger as it will not admit of delay. So we're really not supposed to be keeping any kind of standing armies on our states. This was part of the big brouhaha with California, is sending the Marines in to California, because we're not supposed to be keeping any standing armies at any time, except in a time of war. And what does Anna say about that? Well, they declare some war every 2 years, one, to keep their funding, and two, to keep their standing armies active on the states, when we could just be sitting in a time of peace. Okay. All right. So I'm going to end right here, and we'll pick up at Article 2, hopefully next week, begin to really study this, and we'll get into eventually the 19 enumerated powers. So, all right. So I've got a few questions. I'll take a few questions here if I can answer them. So Betty is not exactly on topic today, but Anna and you said the public notary was affirmed by the General Assembly. Does that mean the public notary is elected by a General Assembly and not the General Assembly? I believe Anna has sort of reversed that. Believe that the public notary can be elected by the General Assembly. Remember that a public notary is only there to witness a signature. It doesn't do the job of a recording secretary. Recording secretaries are there to not only record, but publish documents. So there's a real separation of duties there. And generally, public notaries are there to witness public documents. So if we went to, if you had a will, you could have that witnessed by your public notary or by your recording secretary. If you had, a deed to a piece of property, you could have that notarized by a public notary. So, so realize that there's a little bit of difference in the duties and what they can do. And a public notary has a great deal more in terms of a duty to keep more ledgers of the documents and exactly who, the what, when, and what document that they actually produced. Okay. All right. All right. Is a dollar equal to 3.371 grains of silver rather than an ounce of silver? No. So it depends on what dollar you're talking about. And so with, if you're talking Federation dollar, you're talking about 1/10 of an ounce of gold. If you're talking about a United States dollar, well, I can't exactly say that it's worth anything other than the special paper it's printed on and the ink that they used and the labor they used to print it, about 4 cents. I usually hold up the example that when you have a dollar, you have a $1 bill, it's worth 4 cents. When you hold a $5 bill, it's worth 4 cents. And every time they put it out there, it is the amount of more debt that they actually accumulate when that's passed around. So, so for example, a $5 bill is basically $4.96 worth of debt. $10 bill is $9.96 worth of debt. So what is it worth? Well, when it has nothing backing it, it's worth nothing. It's fiat, meaning it just appeared out of space and time. Okay. So it's not necessarily, there's no way at this point in many ways to equate that back. And it's going to be a tough proposition. There's going to be some balancing that goes on. So I wish, a silver certificate would be worth whatever the price of silver is, $34 or $35 or $36, whatever the current price is. Okay. So the 371.25 grains is actually the mixed weight of silver with some type of a metal like nickel and copper. Okay. So so that's what it's supposed to be worth. But because we would have to prove that there's an actual physical amount of silver to back that dollar, I don't know that we can establish an equality in the dollar. And I hope that made sense. Okay. Oops, I didn't show the question. Sorry about that. Okay. Come down here. Let's see. We continue. All right. I'm just going to answer this question. It's not exactly on topic. Can you tell us about the court win Ohio had that was briefly mentioned last Thursday in the coordinator meeting in the chat, please? So Ohio had a man who basically was a felony contempt of court, a felony resisting arrest, and a felony domestic violence assault, of which there was absolutely no evidence, none, to the effect. And so Ohio, we pulled out all stops from our court. We tried removal orders. We wrote a couple of writs of mandamus. We filed lots of paperwork. And the court continued to stomp right on top of all of that and on the man himself. And I will tell you, the win has more to do with the man following the coaching than it did actually with anything that the Ohio Assembly would have done to try to change the situation. But because of that, because he was courageous and he listened and he learned. He went into court, and the only thing that we told him he could do at that point, essentially, when all else failed, was to create flaws within their court, meaning to bring up constitutional challenges that they could not meet, that they would not hear or expose in due process, that we could expose practicing law from the bench on the record. We went through all of these things, and finally they came down to trial, where they were going to do a bench trial. The judge ordered a bench trial, and he declined and said, I want a trial by jury. On the record, the judge said, well, I'll give you a jury trial. And he said, that's not the same thing. The judge says, yeah, it is. It's the same thing. He says, no. He said, it is not the same thing. And Ohio has declared it's ex parte Milligan. Oh, that doesn't count in this court. Well, what does count in this court? Because you're an inferior court to the Supreme Court, and they say, yes, it does. It was all on record. Okay. Objections were filed with the Attorney General's office, with the Solicitor General's office, with the Supreme Court. We had done all of those things. We created every flaw. And the idea of creating flaws within the court, within the trial, and all of the proceedings is that if he did lose, then an immediate appeal could be made based on the flaws within the court. So it came down to the jury trial, not a trial by jury. So every man and woman that were on the jury were U.S. citizens. And essentially, we told him to go through and impeach every witness on the record, impeach them all. And he kept asking, are you an American or are you a U.S. citizen? Have you changed your political status from U.S. citizen to American? And finally, the judge got a little tired of it. And he said, are you going to impeach, he used those words, every witness? And he said, yes, because these are not my peers. And the judge says, that's it. We're going to trial, right? So they go into trial. Now, these jurors have witnessed everything. They've watched him stomp all over this man's rights and the man's ability to explain exactly why this was an inappropriate setting for his case. And yet the judge proceeded on, and so did the prosecutor. So they go into jury trial. They make his wife a hostile witness because there was absolutely no assault involved. She was having a health crisis and bumped her head, and he was charged with assault. Okay, so within that, they went to jury trial. They made his wife a hostile witness. They beat her up on the witness stand, something fierce, and stepped all over his rights in the process, denied him cross-examination, wouldn't allow her to speak freely. All of that was, and I told him, I said, keep a pad, write it down every time. And he did that. And when it came down to he called me, and they had just gone on recess before they were going into final closing comments. And I said, this is where you shine. I said, the final closing comments in a trial cannot be stopped. The judge may not interrupt you in your closing comments. And I said, in your closing comments, you point out everything from the very beginning of where they were all U.S. citizens and why that was inappropriate for a trial, why they were not in your jurisdiction. Essentially, he red-pilled them, every one of them. And then I said, you explained throughout the trial how they stepped on your rights, how they abused your wife, how they went through and didn't allow you the right of cross-examination, which you're allowed to, how how various things were shut down without the ability to adhere to your American status. And I said, and you explain it to them. And I said, and you explain to them what really happened and the assumptions that were made and the oversteps of your rights that were done. And I said, and if you're successful in your closing comments, I said, you'll be found not guilty. He maintained his innocence all the way through. And that's a really important part, is because from the very get-go, he kept telling them he was innocent. He stated he was innocent. He would not plea not guilty, no contest, or guilty. And they wanted him to, because it shifts the burden of proof. When you plead innocent, it is the court's obligation to prove you guilty. If you plead not guilty, then it is your obligation to prove you are innocent. Okay? So he maintained that all the way through. And so he made his closing comments. And it took the jury 20 minutes. And they came back in and proclaimed him not guilty. That was 3 felonies. And it was all by process of taking and his courage, his ability, his learning ability that he had to state his case. And he had the backup of all the documents that we helped him gather, put together, and put in that he used as exhibit. And so that was kind of the entire process of what we went through. And now that he's found not guilty, now he gets to go back in. And now we get to true bill them for all of the usurpations that they did on his rights. That's actually going to start to take place tomorrow. And he will be able to bill them essentially on that usurpations. And then he'll submit 3 of those true bills. They also include an intent to lien statement in the true bill that sets him up for filing the lien process. And then he can take his judgment along with his lien and his charges, and he can file that agricultural lien. And it will, we are hoping that the effect is that it will shut down the county, because it's not only, it was the municipal clerk of courts, the municipal court, the sheriff's department, the county court, the county clerk, the county judges. And we also, in that, had also included in all of those notices our Supreme Court justice, our Solicitor General, and our Attorney General. And they all have the duty to shut down inappropriate proceedings, and did not. We even spoke directly with the Solicitor General's office on Ohio. And they basically said that they could not interfere in the court, which is not true. We know it's not true. And so we're going to be working on that. It continues. The saga will continue. And hopefully he will be successful in all of that. And what will happen is it's going to shut a county down on Ohio, one of 87 counties. And if we're successful in doing that, at least even temporarily, it's going to teach the other counties a huge lesson in terms of not treading on the rights of Americans and their right to a common law court. And so that is what we're hoping is going to occur. And, that's kind of where we are in the process. So we're moving on, and we're hoping that's going to be successful. We accept all prayers for his success and our litigation teams. And so, it will send a large message. If we can get that done, it's going to send a large message to the other 3,139 counties in the United States. So, that's what you can be doing, is cheering for our success and praying for success. Okay. All right. So I thank you all. Ohio just did another court case. We did our court was open. We just did a court case for a guardianship and asserting our state right over our inhabitants, as well as nullifying orders on in another jurisdiction. So we are really, continuing to work hard. Although the Ohio Assembly has taken a little session break, we get the month of July off, so that everybody has a little bit of, our courts continue to operate, our oversight committees continue to operate, and of course, I still have work to do in the background as well. But we at least get a little bit of a break, a little bit of breathing room from all the meetings and things in this time period. So, we're continuing, and we'll keep you posted as things open. So, we ask for your continued prayers and success. All right, everyone. Well, thank you very much. I'm sorry Anna didn't join us today. I'm sure she's probably busy on some international issues. So, I will see you all next Tuesday. Have a great week and a wonderful 4th of July. And oh, by the way, that's Ohio's first anniversary of their public government, 4th of July. So have a wonderful celebration. Be safe. Keep your head on a swivel. And we'll see you next Tuesday. Bye all.